Attorney Mike Marcello, David Collins, Jennifer Hilton, who is our first alternate, Julie Barrett, who's our administrator, Alzabak. George, where'd you go?
I'm right here.
There you are. Joel is our second alternate. Wendy Taylor Humphreys, a voting member. Jack is a full voting member. And Deb Janik. I don't know who you are, but hi.
Lisi, Deb is the town council liaison with the zoning board.
Oh, hi. Welcome. Hear us?
She has herself muted. I don't know if she's there.
Oh, that's okay. So, there's going to be and I think our speaker is Marianne.
Yep, I'm here.
Okay, very good. So here, I think we're all set.
Okay.
So, the first we're going to call is an appeal has been filed by the Highland Ridge Farm LC.
Can I stop you for 1 second? Your microphone keep cutting in and out. I don't know if you want to adjust it or do something with it.
This is where I live, George, and this is what we.
Okay, sorry.
Okay. So if you don't see anything, yell if you don't hear anything.
We're telling you.
Highland Road Rear, appealing the cease and desist notice from the building zoning official. The property is located in an R40 residential zoning district, and residential dwellings and farming only principal use by right, together with their associated accessory units. So, Beth Noonan, are you here?
I am.
Okay, there you are. I hope that wasn't your house that went up on Prudence.
No, it wasn't, thankfully, yes.
Good.
Thanks for thinking of us.
So I know that this has been subject of some discussion with Marcello and the board. And I think, correct me if I'm wrong, I think this is somewhat moot at this point. Am I right?
Mike,
Beth?
I'll start, sure. I believe it is. The first part there were really two components of the cease and desist that were issued by Mr. Moore. The first had to do with tree cutting, and in a subsequent letter to my client, he indicated he could cut trees so long as he put in the silt retention, issues to make sure that there was no runoff. So I believe, and Mike can hopefully verify that portion is moot.
I think we're on the same page as that.
Okay,
that's correct.
great.
Just for the record, I just want to reference that letter, Beth. It was a letter, the second letter was issued on
October
28th.
October 30th. October 30th.
Yeah, you're right. Right.
Okay, correct. All right. So I think that puts the tree cutting.
I think that's incorrect. That October 30th letter is to the zoning board. There's another letter. Hold on a second.
It was one either Christmas Eve, I got one, or early January. It was or New Year's Eve. Yeah.
Well, I think whatever.
Just for the record, so they're clear, it's a letter dated 12/28/2020 to Highland Ridge Farm from the building inspector, which will enter into the record of these proceedings. So that, yes, based upon that letter, the issue of the tree cutting becomes moot.
Okay, thanks. Right. And then the second part of that, Madam Chair, had to do with the extractive industries and a non-conforming use, and whether or not operations that my client is doing now were violative of the town ordinance. And I've set forth in the appeal documents, and I had conversations with Mr. Marcello, that issue procedurally is not properly in front of the Zoning Board of Review. There's established Rhode Island case law on that issue. To the extent my client and the town have a dispute on that, Mr. Marcello and I would have to be in court to have that resolved absent agreement. So it's not in any way a ruling on the merits. It's merely that in front of this board tonight, the Zoning Board of Review lacks the jurisdiction to consider and weigh in on the existence of non-conforming uses.
I agree. I just want the board to know that I looked up the case law that was cited by Ms. Noonan. And indeed, we do not have the subject matter jurisdiction to delve into whether there's a grant rights or a pre-existing right. And I think that's better left to the Superior Court. So can we, by agreement, pass this off our calendar with the understanding that this is not a ratification or endorsement in any way of the gravel application or the claim that's being made by the, and that's something that's got original subject.
Lisa, I can't hear you. You're cutting in and out. It's Mary Ann
Yeah,
talking.
this is where I live, you know, I'm sorry.
It's okay. Well,
My only concern, Madam Chair, and I leave it to maybe Mr. Marcello has some ideas. I don't want it hanging out there that we have an unanswered violation or that it hasn't been resolved. So
No, I think it's become moot, don't you?
the notice of violation on this issue,
Yeah.
yes, I think so.
On the first, but it's cutting down trees. I think the town has been very proactive and, addressing the issues that they were important to address. And I don't think that's a matter we need to litigate tonight. I think it's sort
I
of
agree.
been resolved. And as far as the validity of a gravel permit, I think that is subject to a review by the Superior Court that has the jurisdiction to do that.
So just so the record's clear, so the appellant had cited a number of cases that's in their brief over the last 7 to 10 days. I along with the chair looked up those cases and I forwarded them to everyone. She is correct. There's Rhode Island case law that a pre-existing non-conforming use it is beyond the jurisdiction of this board to determine whether or not someone has a pre-existing use. So what my recommendation would be is that we find as a matter of law that this board does not have the jurisdiction to rule on such a matter and uphold the appeal on those grounds, with the understanding that we're not suggesting whether he does have or does not. We just don't have the jurisdiction to decide it. And Mr. Shea, you're there. I don't know if you have any issues with that.
Beth, is that
This will be
Yes.
proceeding to Superior Court to make the determination.
Yes, and speaking with Ms. Noonan today, she's prepared and about to file a declaratory judgment action on that very issue. So that's where it's going to get decided.
And the decision to pass the motion today will not have any effect on a ruling on the merits, whatever it may be someday.
No, it won't. I mean, I think that the initial notice of cease and desist has sort of been supplemented by Mr. Moore's subsequent letter. And I think everybody agrees that there's no issue before the board at the moment. And I think we should just pass it off the calendar.
I'm not sure that would be the best. My thought, I agree on the tree cutting. I think that can just be passed, the sections that pertain to that. On the other matter, I think I agree with Mr. Marcello that there should be a holding that our appeal should be upheld just purely on the jurisdictional grounds.
Jurisdictional matter, based on a lack of jurisdiction. That's what I would recommend as well.
Yes, well, I agree. I think I'm in agreement. Agree, we don't have jurisdiction to decide the issue. So that would be my motion.
Can you state the motion?
Yes, the motion is that the first portion has become moot. And the second portion is the jurisdictional question is within the sole province of the Superior Court. And we do not have subject matter jurisdiction to decide the existence of a permit, grandfathered or otherwise, for the gravel.
All right, I'll second the motion.
All those in favor?
Might be just, okay. I don't know if you had a discussion, that's fine. We need to do a roll call vote, by the way.
Okay, fine. Voting in favor would be myself, Lisa Kasha, Dave Collins,
Agreed.
Jay, Wendy.
Agreed.
Okay, are we there? And George,
George.
where are you? I can't see you.
I hear.
George, are you voting?
Yes, I voted. My hand is up.
I can't see you.
My hand is up. I don't know why you
Okay.
cannot see me.
Okay, so I think we have 5 people that are voting in favor of the relief, which is the Superior Court has jurisdiction and the other issue is moot. So is that good enough?
I think so.
Yes. works.
Beth?
Yes, that's fine, Madam Chair. Yep.
All right, good.
Justin, you have any objection? Justin, you all set?
No, thank you very much.
All right, thank you.
Okay,
every-
thank you, everybody.
Thank you.
Thank you
Can
for your
everybody
time.
else see me?
Yes, we can.
Oh,
I
okay.
can't.
Thanks, Beth. Thanks, Justin.
Thank you.
Thanks, have a good
Sorry,
night.
Justin, I didn't see you there on my screen, so I didn't introduce you. Sorry.
Thank you. Everybody have a good night.
Thanks.
Thank
Good
you.
night.
Okay.
Lisa, do you have your computer set up in gallery view so you can see everybody?
I don't know what that is.
I was just about to say that. If you go to the upper right-hand corner, it says
Yeah.
view, and there's a bunch of squares.
Ah, okay. I think I can see everybody now.
And while you're doing that, I just wanted to interject for a second. I'm Deb Janik. I'm from the council, and I am your liaison. So I just wanted to hop on tonight to meet you all and say hello.
Well, thank you for coming
Thank you.
and forgive me for my ignorance with the Zoom.
No worries. I was late. I was taking a call as you started.
No problem. Thank you. So we have one other matter on the agenda, if I can find it. I'm sure it's here, which is a matter that's been filed by Daniel Abram, AP 301L116, a zoning application for a variance. I'm sorry, I can't find. Hi, Court.
Hi, how are you?
You're under William Moore.
Oh,
You threw me a curve.
I see me under Court Chappelle, but
Well, that's all right.
You're fine, Court. It's not you.
Yeah, thanks. So, Court, are you presenting for your son tonight?
I am, and I do have Mr. Abraham sitting 6 feet away to answer any questions. And probably in the audience, we expected Lynn Small from Northeast Engineering. Again, just if you have any questions of her. So very briefly, what we have is Plat 301 Lot 116, which is a pre-existing non-conforming lot, which is only 3,889.7 square feet. And prior to the introduction of sewer in the area, may not have been buildable, but the Abraham family has owned it for, I think, since 1978. They are also the abutting property owners, and my client Dan and Lauren moved in there when his father passed in March of 2020. On this back lot, they're proposing a garage, which ironically can't stand as a garage alone because under Tiverton zoning, we can't have a accessory
For
use
you,
on a
right.
lot that doesn't have a primary. So we are actually, because he has 3 kids who are all successful and all who live out of town, he's looking to put an apartment above it, which will qualify it as a dwelling unit to pay full taxes on, but he'll be maintaining it for the use of his kids when they come into town and the garage because he needs more storage. Now, with a 3,889 square foot lot, your ordinance, it's an R40 zone. Your ordinance set forth what the front yard, rear yard, side yard, and lot coverage would be. Excepting the front yard, your ordinance says for side yard, rear yard, and lot coverage, you are to divide the 3,889 square feet into the 40,000. and you're to get the percentage that it is below the standard. And in this case, it's 90%. You're then to look at the rear setback, which is supposed to be 40. You could subtract 90% or 36. It would result in a 4-foot setback, but your ordinance has a minimum that it will be at least 10. And in this case, we do not need a variance because we are, I think, 17 or so and more than 10. On the side lot lines, it would be 25 feet. But again, when you do the math and the reduction, it would reduce 90% of 25, which is 22.5. It would result in a 2.5-foot setback. But your ordinance says not less than 5 feet, and we are at 15. The lot coverage would be 25%. Again, when you do the math, we could take it down to up to 986 square feet. I think that you're going to find that the least relief necessary is exactly what we're doing. This is a 24 by 24 building, which is a standard garage, so that we can get a car into that depth. That 24 by 24 is 576 square feet. Because of the apartment, it's going to require a set of stairs to a door in the back, which will not need a rear setback. And it will make it 628 square feet, still only a 16% lot coverage, despite the fact that it's such a small lot. So it is a 1-bedroom unit that we request. It is no variance on lot size, no variance on rear yard or side yard. Unfortunately, that percentage in the ordinance does not apply to your front yard setback. Your front yard setback is still 40 feet. And because of the topography of the land in the back, if you know the area, this abuts the old railroad tracks, which is a kind of a drop in elevation. So we can't safely push it back any further than we've placed it, given the fact that we have the 4-foot stairway in the back. So the end result is, as far as we can get it back, is the 28 or 29 feet off the property line, which results in an 11-foot request for a front yard setback. My argument to deny would make this lot unbuildable, which is certainly a higher standard than more than a mere inconvenience, and the least relief necessary, because if you're going to put a garage in and we only have the width to enter from the front, I think a 24 a foot garage or a 24-foot single family 1-bedroom apartment is just about as small as you've seen come in front of you. So I think the request is reasonable, and I ask you to approve it. I do see Lynn Small if you have any of the engineering questions. I think the only true question of hers is, could you push it back further to make the least relief necessary? And if you bring her on, I'm sure she'll tell you that given the stairway that has to be in the back, we push this building back as far as it can go. Now, even if you approve it, remember, this is just preliminary for us because we need to go to DEM and get our approvals because of coast. It's not in the wetlands, obviously, but it is in a perimeter buffer. So we'll need to go there, but we need to get town permission before we go to state agencies, much akin to the argument you hear in when we need to go to coastal resources.
Okay, thank you. Does anyone have any questions of Mr. Chappelle?
Yeah, I question.
Ask away, Dave.
My question concerns the problem behind the house. Was it a drop off, did you say?
Well, behind the house is, I believe, what I call the old railroad. I don't think there's truly tracks there anymore, but it is the railroad. And in this particular topography, the railroad's cut down there. And there's actually, I think it's a lot of runoff from the condos, but it's actually kind of wet there in the railroad as well. But if you were down at the bottom of this lot, you'd have to climb up a 4-foot bank or so to get to where this house is. So the further we go back, the closer we encroach on that bank. And our engineer has given us a distance that we shouldn't get any closer to that bank. And DEM is going to want to push us as far forward from the bank as possible. But we are then in the catch-22 of DEM wants to push us forward, and you want, my standard here is the least relief necessary. So we proposed the logical compromise of the two, given the engineering concerns.
So this is a 4-foot drop off in the back. Is that right? It's dropping down or is it going up?
Down, I believe.
Down. Okay. But it's just a slope. There's no rock or fill or anything like that.
It just belongs to the state of Rhode Island.
Oh, you don't even own it. Okay.
Well, when it gets back to the property line, it drops off because it's the state of Rhode, Lynn is on here and she can tell you, but it is the state of Rhode Island right of way. That is the railroad that may be proposed to be the bike path, I guess, but. Oh, so is that Lynn bringing that up?
I did. I'm sorry. I didn't even ask. I just kind of went and did it. I apologize. But I just brought a plan up so I could show you.
If you're to testify, we should put you under oath.
Oh, I'm sorry.
That's okay.
Lynn Small, Northeast Engineers, 6 Valley Road, Middletown, Rhode Island.
And
I'm gonna-
Mary Ann, you want to do it?
I'm
Yeah,
gonna
go
start.
ahead. Go ahead,
Do you-
please. Mary Ann, go ahead, please. Yep.
Okay, Ms. Small, can you raise your right hand? You solemnly me swear the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth. So help you God.
I do.
Okay.
Thank you. Sorry about that. I didn't realize. I don't know
Yeah.
what I was thinking.
Little formality. The
We're
oath.
all a little out of our norm, right? By the time we get used to this, it'll end. So
Lynn, am I correct that that's you controlling that little hand I see on our screen?
it is. I shared the screen and I zoomed in on our plan. This is our plan that we submitted with the application package. And I zoomed in so we could look at just the area of concern so you can see where the back property line is. And that this is owned by State of Providence Plantations.
So our standard in asking for the 11-foot variance in the front is that it's the least relief necessary. And since we could technically go further back, given the calculations of the ordinance, can you tell us why, as a practical matter, we can't push that garage back any further towards the rear property line, please?
Certainly. We are asking for relief in the front. We do show the building envelope right here. You can see that dashed line. So you could technically push the building back per zoning, but we have this stream that runs back along here, and the perimeter wetland, the riverbank wetland associated, extends all the way over to here. So what we're trying to do is kind of split the difference, if you will. Get a little bit of relief from the town. We'll have that obligation required when we go to the state permitting, because the building is entirely within the riverbank wetland associated with the stream that is in the back. So we need to demonstrate that we're asking for the least relief possible with the state, which forces us to ask for relief at the local level as well. From an environmental standpoint, it's better to provide this additional separation from the stream than to push everything right back. This will give us a little bit of space to put, some water quality treatment back here as well.
And there's room for the 4-foot set of stairs that are going to be required by the building inspector for the access in the back.
Yes, there is room. Or if they go, where we have room over here, or over here, right?
They will not require a variance.
Correct.
And then this will be connected to sewer, right?
Yes, we have already had, once the building inspector told us that it was a buildable lot subject to at least this board's opinions on what we needed to do, we had the stub installed when the sewer line went in. Remember, this is a pretty new sewer line that just went in. $16,000, by the way. Do you know, do you know that a butters list was $1,600? Because whenever you live next to a condo, you have the privilege of notifying every member.
Yeah, that's nice.
Oh my God.
in Portsmouth, we're trying to put into our condos that part of the declarations when we approve a condo are that they can accept notice as part of the documents in a master notice to the board.
That's a good idea.
Obviously, you're way ahead of Tiverton.
So on this garage, do you actually plan to put cars in the garage?
The first floor is just the garage, and then there is a
And
just
how do you get into the garage with a car?
right from the road in the front.
From Poplar Street or Poplar Drive? Yeah.
From Poplar? Okay.
Right here? Well,
Yeah, I would call that the west.
Right.
does any member of the board have questions for Ms. Small?
Is Poplar Drive an actual road of record?
Yes, it is. And recently when they put the sewer line in, they actually put some pavement on it.
Okay.
So now you can drive along Poplar and onto, I think it's Secundit or Schooner. You can get to Schooner
Yeah,
now.
you can pull right in. Yeah, they did that a few years ago, right?
I think they just paved it. But
Oh, probably after the sewer.
I think they waited for the sewer probably is what they did.
So you can go here to the boathouse?
Yes.
Nice.
Is Poplar Drive a town road or is it a private road?
It says right on the plan, public way. I believe it's a platted public.
It
road.
is, right, I agree with you, Court. We found that it was a platted public right of way. It is a little narrower than normal. It's 25 feet versus 40 or 50, but it is a public right of way.
Can I ask a question?
Yes.
All right, so if I'm looking at that plan here, I see a property just below these two. You might not know this, but you know the answer. But is that like a mirror property right below this applicant?
Well, it was Batch. Is it still Mr.
Batch?
Mr. Batch lives there and has his home similar to my client's. And then he also has a barn very close to the road on the lot that he owns across the street. I don't think his barn is developed or anything, but I think there is a barn on the right-hand side.
Yeah, the reason I asked, because that's another fogland, another tight area. We're gonna start fitting places and properties and make it tighter and tighter.
If you look at the aerial view, he already has a shed or something on it or a barn on it.
Now, I drove down there. I didn't know they were owned by the same two people, same like mirror property. I drove down there and looked at the property.
In the back, yeah. And again, I'm not sure if it wasn't for zoning, we wouldn't just put a garage on this. That's kind of how it started, but
Or put nothing on it because it's in the middle of a place where they put a zone where you cannot, the water protected, put nothing. That's why it was divided by a road or not
right,
approve anything.
but it's a platted lot that they unfortunately charge us full value on taxes and make it buildable and
Yeah.
you can merge it to your own lot because there's a road between it. So it really just says, I got to get some value out of it. And this seemed to be just a smallest use possible. And he gets the benefit of a garage, which on his house he needs anyway. You need some storage there anyway. So it just seems to work with the ordinance and work with the area and minimize the size and stay in the
Court, what about rescue vehicles? With this Poplar Drive being so small, has anyone reached out to the fire department? Do we know if rescue vehicles can get to this area based on how congested it is and how small the properties all are? And they seem like they're going to be right on top of each other. And now we've got this road that's slightly undersized.
Well, I know that. I'll have Dan answer that, but it is way easier to get there today than it was a month ago because they've paved the road. Before that, the road was paved kind of up and short of this on both sides, paved on both sides, but in the middle was not done. And depending on how wet and rainy it was, whether it was an emergency vehicle or your car, you chose a path that went across someone's yard or on the right of way or wherever you happen to land that was dry.
Can I,
If you got to be sworn in if you're going to talk. I got to put my mask on now. I'm closer to 6.
actually, while we're doing that, Mike, can I ask you, do we need to hear from the fire department or any of the rescue departments on this to see if they've deemed that they have appropriate access?
Madam Chair, I could comment.
Yeah, go ahead.
This is Bill Moore. I'm the building official. Dan Murphy, the fire marshal, is available if we need him, but I would point out Poplar Drive has been there for a long time. There's about 40 houses up there. You used to get there by Riverside Drive and snaking your way up. And about 10 years ago, they opened it up to Schooner. And, you know, even though there's a do not enter sign coming from Schooner, I'm not sure anybody reads that. But it is a roadway. The town does service everybody up there. But Dan, if you'd like, I can contact him and he can get on if he needs to. And he's the fire marshal for Tiverton.
Wendy, would you like to do that?
You know, if our building official says that everything is good, then I will defer to him.
Everybody else good with that?
Yeah.
Okay.
Question,
Yes.
can you describe the immediate neighborhood around this structure or proposed structure?
I can, Dan can probably do it better, but do you have the map in front of you? So let's start to the north. To the north is kind of the vacant land that's part of the boathouse Schooner Drive property. So there's no affected neighbors, I guess. If you go to the east, that's the railroad property, which may be a bike path someday, but is a long way and not any houses. The immediate properties to the south, I think it was pretty good description to say mirrored from his house is a single family house that the Batches own that are right next door. That's similarly located on the lot as the Abraham house. And then he owns the same lot across the street like my client does. And he owns a barn on that lot, not a residence on that lot. He might've had some grandfather rights to have an accessory building on it. I don't know. It looks like that barn's been there 100 years. But that's the neighborhood. As you go down Schooner, it's just, down Poplar, it's just single family houses that are all, you know, a lot of garages across the street and a lot of houses of similar size and quality.
So if you were to comply with our zoning requirements, what would the size of this building be? It'd be what, 24 minus 11?
We could, as to size of building, we could go 300 square feet larger. And if you look at the drawing that's in front of you, the building envelope is actually on there. We just can't push it back. So if we were to maintain the back based on what the engineer is and comply with the 40 feet instead of 24, our building would be 24 minus 11 or 13 feet. And we would be asking you to approve a trailer that we couldn't park a garage in. Because it would be 13 by, now we could make it more than 24. We could make it 13 feet by probably 40 feet. But again, that's a trailer. And this is not a neighborhood that we want to put a long single building in. It doesn't serve our purposes either as a garage, because at 13 feet, since we can only enter from the west, we'd have to swing a Mini Cooper in sideways to get it in there.
I have a question
Yes, George.
to the engineer. So you pointed out that you have put the setback from the railroad because you're trying to compromise for the next hearing with the Rhode Island Authority or Water Authority, whatever the Rhode Island Authority is.
Yeah.
Freshwater wetlands.
But thank you. The question is, you made that decision based on hopefully you'll get a decision, favorable decision from them, but they could easily say no, right?
Yeah, we have to do an application for freshwater wetlands. One of the things is we have to demonstrate the hardship and what we've done to try to help overcome that, which means we go to the town, ask for some relief so that we can push the building farther from the stream. But you're right, this is a conditional approval because we're not done. We can't go to building permit at this point. We have to go to DEM and get a permit to
Okay,
put a building within the perimeter wetland.
And if
So
DEM pushes it forward, we'd have to come back to this board and say, we only have a variance for 11 feet. Will you consider 6 feet because DEM made us do it? Remember also that there's not much room because we have that 4-foot stairway in the back. So we can't go as a matter of right too much further anyway.
so my question is, you are building this garage, you got into a court, that was my question, next question is, so you building it and you put an apartment above it and then you put in the stairs in the back, is those 4-foot stairs you're talking about?
That's because those are required.
Okay, they cannot go on the side? Like, do they have to be in the back of the building?
They could be, I'm just doing my math because we were trying not to get too many variances for you.
I understand. I'd like to be away from the street as much as possible to give you a variance on the side.
I
rather than put you
think,
close.
I think the answer is if we shifted the building to the south, closer to the neighbor, or to the north, closer to that neighbor, we could make room on the side. But if we pull it back, we also don't expect DEM wants us to put it in his yard on the other side of the street. That's where DEM.
So am I, but that's beside the point. I don't know. I feel like we're worrying about the next application and all I care about is if I could put this building back and you put the steps on the side away from the street, that's how I feel more comfortable. We'll continue listening to the rest of the board.
The stairs aren't going to be next to the street. They're going to be.
No, I understand. I'm saying I want to push the building as far as away from the street as I can. You could put the steps on the side of the building.
May I ask Lynn a question? Lynn, could the entire building go back 4 feet and I move the stairs to the side?
I mean, we can, yeah, I mean, I can't predict what the state is going to say. The setback is 100 feet, but 4 feet is not, as long as we have some space back here to do water quality treatment, because, I mean, at the end of the day, having the building a little bit closer to the road so we can protect the stream is actually a better design. But if we're moving it 4 feet back, I think we'll have enough space to do that water quality treatment still. So I don't think that'll be too difficult.
Our job to give you the minimum requirement is that if I could get you to go, if the guy
Everyone wants to give us the minimum. Yeah.
So I like you to go back 4 feet and put the steps on the stairs, and then you got my vote.
And if DEM turns us down, I want to come in and say, now it's the least relief because DEM wouldn't do it.
I understand, but I can't worry about the next person. I got to worry about what is front of me right now.
And the downside is that's going to cost me $1,600 in advertising to do that. Although I may be able to do it with Mike's blessing as a motion to modify an assent.
If
Can we get the violins out now, Court?
What's that?
We get the violins out now?
Thanks for stepping up, Lisa.
I get it, but I mean, think about it. I've been doing this a long time, and that was the highest check we ever wrote to send out certified mail.
For a tiny little lot, yeah.
We're gonna be approaching the town council to change the local ordinance to allow first-class notification. So,
Lynn, is it practical that DEM will draw a distinction between the building being 4 foot back as opposed to the stairway? Are our odds the same? Is it something we should? Is there a number there that 4 feet we can live with, or?
I don't have any real guideline on that. you just try to disturb the minimum possible. In all reality, from an environmental standpoint, stairs are not impervious, whereas the roof is. So if you're gonna look at it, hard environmental, it would be better to have the building closer to the road and the stairs in the back because they're pervious.
Could I amend can I amend 2 feet without jeopardizing your application?
Are you talking to me?
Yeah. Could I
Oh, I don't,
I
it's
want to
hard.
give them
to
as
predict.
much
The
as
state
possible
doesn't
without
have-
making it a useless trip to DEM. So
Yeah.
that's why we bring you as the expert on what's possible.
But
here's my,
I can't predict how much the state will give us for relief. All I can demonstrate is that we approached the town and tried to get the maximum relief possible. And then if we had to, change that, so we're reducing the relief from the town level, that's something we'll put in our narrative to the state, that during the process with the town, we had to reduce it even more. But we can try to make the argument. Can I guarantee anything? No. I mean, unless we're meeting code.
Court, my other problem is that we're basically amending the application on the fly here. So the notice went out as this application. Now we're gonna modify it, and I'm not sure the notice would be appropriate at that point because it's a modified application.
Well, the only thing I'm going to say, Mike, is I believe there's a lot of case law that says if it went out with an 11-foot variance, we could grant a 9-foot variance without motion. What we can't do is if moving it back created a variance on the rear lot line, we couldn't do that because no one's been notified of that variance. So I think we could move it 2 feet without notice, but that's up to you, because generally we take the position that if you've notified all neighbors that it's going to be 11-foot variance, you can grant them.
So it would be a less of a variance and not
Right.
9-foot, right.
But
I agree with that. I agree with that.
Go back far enough to create a rear line, and neither of these would. So
I agree. I mean, all I just point out is we're talking about, you need, it's up to the board how they want to handle it, but that's just, you have one member concern, that's all.
The question I have back to you, Court, as you look at Justin from 4 feet to 2 feet, you have not guaranteed to even get this as the way it is. So we're asking to go back 4 feet, or I'm asking, you go back to 4 feet. What difference does it make if you're not sure you even get the application approved?
you're right, but from a landowner's point of view, and I'm not doing violins, but we have a number of places to go to. So we hire experts to tell us what's the least relief necessary we can ask the town and get some reasonable likelihood. Because I know we could have just put it in the back and gone to DEM and just gotten turned down, because they're going to say, what's our least relief? Why didn't you ask the town? Now, when we ask the town for 11 and they only give us 9, at least we can say to them, we asked for more. It's all we got. That's why we're hanging on you. But we have to kind of do one first, and it has to be practical. We also, in this case, it's a neighborhood that everything around it, nobody has 40 feet. Most of the other houses in this neighborhood are at 10 feet and 5 feet. Although we ask 11, there's still 26 feet from the property line. It's not like it's a.
So if you give me those 2 feet, I'm sorry if you're not giving me, but we're just talking about it. So you're still putting the steps in the back for the engineer? I guess that's the question.
I think you need 4 foot minimum, so 2 feet doesn't really make a difference.
Right.
Other than, giving us a little bit more space from DEM. But I wouldn't be able to put the stairs in the back. Oh, you're saying, well, we could try.
Well, but if they need to be moved to the side, we could do that without a variance, correct?
Right, yeah.
So I would, again, I'm trying to please everybody, and maybe nobody else cares about it, but I care about, as long as we can do it. And I think it allows us to say to DEM that this is the least relief necessary, because they wouldn't, there were members concerned with giving us 11. So if it's all right with Mike, I can amend our petition to ask for a 9-foot front yard setback and to show the building as located, the 24 by 24, staying without variance on any side and moving back 2 feet. And where the stairs go would still depend on either DEM and, you know, if they have to go on the side, we'll put them on the side. But I think we can legally shift this building left and right with the building inspector, as long as we don't get closer than the minimums carved out in the ordinance. Do you agree with that, Mike?
Yeah, I'm okay with that. I mean, again, it's up to the board. I mean, we have one member who wants it 2 feet. I don't know what the other board members think. It's up to you if you want to go through this. But, you know, again.
No. Well,
That's,
I'm
I know
assuming
it's one
everybody
member.
wants the least relief.
Right, that's our job.
Yeah.
Does anyone else have any questions of the witness? Does any member of the public have any questions or want input? Nobody there? Are we ready to?
Well, let's take a second there. Let me see, make sure that there are nobody, anybody in here that might want to speak in favor of the application. Please raise their hands on Zoom.
Can the engineer take this screen out? Thank you.
Does anyone want to speak against the application who might be in Zoom? Please indicate by raising their hand.
I can't understand you. I'm sorry.
I'm sorry, I'm just asking if people are in the attendees who may on the audience who may want to speak for or against the application to raise their hand. It's a public hearing, right? No one, madam.
How
No
many
one.
notices and none of them showed up?
There are 3 people on attendees. No, Madam Chair, no comment.
1,600 divided by $4.45.
There were 241 notices that were sent.
So, Madam Chair, you
Okay.
can close, if you're satisfied you've heard enough, you should close the public hearing, please.
Well, is there anything you want to say, Mr. Chappelle, in closing?
No, just thank you, but I think I have formally moved to amend to a 9-foot front yard variance, and you may have to.
No, it's a 31-foot front yard variance. Well, you're asking for 2 more.
I'm asking for 9 foot of relief to set
Okay, I got
back
it.
31 feet.
Yes,
instead
okay.
of
I'm
40.
sorry.
No, we're both right. It's just which end you use, right?
Yeah.
I think you might have to vote to accept the amendment and then vote on whether you do it.
Okay, so how do we feel about, does anybody want to move to approve the amendment of 9 as opposed to the 11-foot variance?
I'm all for the
Well-
9 feet.
I'll second that.
Okay, second by Mr. Jackson, okay. And where are we in terms of discussion? We're going to close it and just have deliberations now. And how does?
You need to vote on the amendment first. You need to vote on the amendment. You didn't, so you got a motion to amend the application has been made and seconded. Now you got a vote to accept the amendment.
Okay. Everybody in favor of the amendment? Wendy, Taylor Humphrey, Josselbeck, Jackson, no hand, you, Dave?
Opposed.
Opposed, okay. Me, so it's 4-1 in terms of granting the amended petition.
No, allowing the amendment. Now you got to vote on the position as
Yeah.
amended.
Got it. Okay. Where do we stand on the voting on the substantive part of the variance petition to 9-foot variance?
Front yard.
Front yard.
I think we gave them, I think we got the best we could get out of it. We gave them the least we could give them. I am okay for the rest of it.
Okay. Does anybody else have anything they want to, to throw out there?
Dave, what's your opposition?
Well, given the choice of having relief to the environment or relief to the street, I'd rather give the relief to the environment.
Okay, thank you.
They're in the middle of the environment. They really know. They're in the middle of it.
There is more of an impact if it's 2 feet farther back.
Oh, okay.
May come
Yeah,
back.
but
They may
the-
come back though, because DEM may say no, and then we'll be here again.
Yeah, I think that's,
You gotta understand, the engineer is gonna do some water mediation,
We've got the room for it in the back still. We haven't moved that.
so there's
either.
room, she stated there was still room to do that.
Right.
Wendy, what do you think?
Same thing I usually think. It's a building on a substandard lot that
Right.
needs a variance, and it's in a crowded area with 40 homes. And I think George referred to it like fogland, which
Yeah.
is completely overcrowded. And this is Riverside area is another area that's completely overcrowded. And if no one's here to object, it makes me very fearful that that just means that the next person on this area in this area is going to want to come, and they're going to want to do the same thing. And it just gets so congested.
Well, I don't think it's that
You
congested.
know, it's a grandfather lot.
Yeah, I mean, it really is.
You know, we can't forget that all this encroachment has happened over the years. I mean, that lot was set up how many years ago? Before zoning.
Hey, if
So,
everyone's
you
going
know-
to disagree and yell at me for my opinion, then don't ask me for my opinion next time.
Ooh, a little sensitive. No, I think we all need to weigh in. I'm not criticizing you. I don't think anybody's criticizing anybody's opinion.
I get upset because DEM's telling you you can't, if you look at that lot line, the restriction that DEM has makes that lot unbuildable. Yet people have been paying taxes on that for how long? And if they want to they want to put something there, they should be able to.
Well,
That's all I'm saying. I'm
tend to
sorry I
agree-
get upset,
Hey,
but you know,
no,
we're
no,
being,
I mean, someone's paying taxes on that lot, and it's incredibly small, but it's been incredibly small. And if they need to put a garage on it, I think this is sort of de minimis. I'm actually surprised that there's that much controversy, with all due respect to everybody. And I really do appreciate everybody's input on this. So, we're all trying to find our way here. I mean, do we deny this guy?
I apologize for yelling at you. Just get fired up about these things.
It's a substandard for a reason. It's the way it got
I
divided.
love a
It's-
passionate zoning board.
All right, let's make a motion.
Hey, go ahead.
No, Dave's good at it, or you. I'm not good at it. My English is not that good.
You're good enough.
I make a motion to approve this application with the amended 9 feet setback. And that's it.
I will second that. All those in favor? You can't vote, Joel. Nice try. Dave Collins, George Alzabak, myself, Jay, and Wendy. Unanimous. So congratulations.
Thank you. I understand
You drew blood.
about,
You
but
drew blood, but that's okay.
I tried to do it as soft as I could. And I
Well,
thank you all, and I will.
You were
see
merciless as usual, but
The plastic knife.
It is.
We
I
won't
could
hold-
see it. I could see it in your. I could see it in your face.
All of you.
come back soon, Court. Come back soon.
Take care.
Okay.
Thanks again.
Congratulations. We've done a lot of work on our application rules of procedure, and Julie didn't have a chance to make the change, which is really a forever rolling project. So hopefully we'll have that in the next 2 weeks to send everybody, and can take that up at the next meeting. But it really does, we've tried to take into consideration our concerns about people not truth on these hearings, and how we can, make the oath and a little more viable by having them swear to the application. And some other rules regarding continuances. And if anybody has any ideas that they think need to be revamped, there's no pride of authorship in these rules of procedure. So if anybody has any suggestions, please send them on. Okay.
You got it.
Okay. Anybody else have anything they want to bring up?
We wanted to talk about the postage with the remainder of the board, just following up on what Court just said. Presently, we're sending all of our notices by certified, return receipt requested. Certified just went up. It's now $6.96 per mail. So we had talked about changing it so it was first class. I know we talked about this once before, but wanted to bring the question up again.
But just so you know, that's a council decision, not a.
Yeah, that was a council decision.
Oh, okay, but I thought we wanted to make sure everybody agreed to it because last time we talked about it, we didn't have a consensus about changing it.
Would we be in compliance with the open meeting laws if we make that change?
I mean by that, Mr. David, I don't understand your question.
I don't think it's an open meetings laws thing. It's a notice requirement.
Yeah, but if we don't properly notice, then we're in violation of open meeting rules, aren't we?
No, so the state enabling statute specifies how notice needs to be sent out for zoning application, zoning, with the 200-foot of butters and whatnot. And state law used to say that you had to send it out by certified mail, but there was a change about 5 years ago that leaves it up to the city or town to decide whether they want to do it by first class or certified or some other method, as long as we can verify that the mail was actually sent. Unfortunately, the Tiverton zoning code was not amended or amended to reflect that change. So our ordinance now is stuck at the certified mail, and it does get costly, especially when you're like a condo, because there's no way around it. Each individual owns that condo separately. They've got to get their own notice.
Okay, so I have a question. Are you okay, as any of these board member here, to be in a butter to someone, especially the mail the way it's going right now? We got all our mail late. We got everything getting delivered late. Are any of you comfortable to get a letter they go in a butter and receive it late, not get signed for it, and show up at the meeting, it's already done, voted, taken, you have no idea about it?
I think that paying $6 to notify somebody, which is exorbitant, and there's no guarantee that that's going to get there in time either.
But it's just, again, the notice is made for a reason, to be received and accepted and knowing that you have a meeting coming. And I agree, probably.
It's posted in other places as well.
How many places we have condominiums in town, but it's change that rule where you have to put a master email to a condominiums or something and notice somewhere.
We can't do that. It's you got to notify.
I think it's nuts. I don't care who's voting on it, council or us. It's nuts. Everybody should have the right to know.
Well,
Rich, just so you know, we also do post the agenda on the Secretary of State website every month. We post it at Town Hall, at the Senior Center, and at the library.
Julie, I agree, but just about, I don't know, a year ago, we had a hearing with somebody who did not notify the neighbors, or I don't remember the exact sentence, but some of the neighbors did not know this guy was building a house, but the way he built the house. I feel like we have the neighbors, the abutter, have the right to know this is happening. And if they don't know this guy's building it, you could list it on the state website, but we don't know he's doing it.
Well, he didn't need that. That person didn't need a variance, so that had nothing to do with anything.
Okay, whatever.
Right, if somebody's building a house, they don't. Yeah.
Exactly. Talking about Ledger Lane, and that one didn't need a variance from us. We didn't need to do any notice for that.
And not us, other people. We're not talking just about us. They're talking notices eliminated by everybody.
Well, I mean, it's a building and they don't need a variance. They're not going to send out any notice.
I mean, we're complying with state law by giving them a regular.
It's only my opinion, just one person. That's fine.
Yeah.
Again, this is really a decision for the town council, not for the zoning board. If you want to weigh in, as a board, you can do that. We're going to try to put a bunch of zoning amendments before the town council anyway that just clarify some things. But again, George makes a good point, but there is a cost, and frankly, most people don't pick up certified mail anymore either because they're afraid that it's a bill collector or a lawsuit or something. So that's the other issue. So just
So
because you get something certified, there's no guarantee that it gets picked up either.
Do we get a return receipt? On
We
first
do not.
class?
We send it certified, return receipt requested. We do not check them. Basically, like, for instance, for Zero Poplar, of the 241 letters that went out, as of today's date, I've received back 3 letters as undeliverable, which means either the people didn't accept it, their address had changed, they had an improper address.
Out of 240 people, just 3?
Out of 241, 3 came back.
Oh, that's my case.
Well, I think this is definitely an issue for the council, but I mean, I don't want to be asking for it if the majority of our board is not in favor of changing it.
I'm in favor of changing it. Not that I have a vote, but I have an opinion.
Yes. Dave?
Well, as long as we comply with the state law, I'm okay with it. But
Jay?
I do like to see a return receipt.
I don't think we get that with first class mail.
You do not, you say?
No, you
Well,
do not.
what you get is, it's the same scenario. If they try to deliver the letter, first class mail, and the address is wrong, they're no longer there, their forwarding address period expired, it gets returned to town hall, whether it's certified or not. What you don't get is a signature, which we haven't been getting through the whole pandemic anyways. The post office hasn't even been doing that. They've just been leaving packages. So it's kind of a moot point at that stage.
Well, I just want to say that over the years, the zoning board has gotten out of trouble on more than one occasion because we had a receipt saying that somebody had in fact received notice of a hearing when they claimed that they had not. So that's the advantage of having the return receipt.
That is true. If we were to go to the first class, however, the law recognizes that if we can prove that we mailed it first class, the law assumes that it gets delivered. So the presumption is on us. It favors the town on first class mail too. The law allows like first class. There's other way you can mail a confirmed receipt. There's certified is the top notch, but there are other. The law allows between first class and certified. There's a bunch of things you can do in between to get to prove that thing's been notified. It really is just a policy issue it's a cost issue. I mean, let's think of this. We just had a guy get a garage basically, and he had to pay $1,600 for a 4-foot setback. Whether you think that's good or not, I guess that's a policy question.
With 994 and 1000 Main, Northborough, if you remember, on November 18th, they had 2 applications before us. Their certified mail came to 4,000.
I'm sorry. I just think that's prohibitive. I really do. But whatever you think, I mean, I'll go with whatever you think is wise. I just don't think it's necessary to have an applicant that $6,000, for what really is minor relief. And it seems to me if they didn't get notice, and the onus is still on them to say they didn't get notice. And Mike, can people do that? Can they challenge the lack of notice? If they didn't receive it, they still get to come back in, right?
Yep.
We have to put them on the screen to talk. If we don't, how would they? I mean, we just stop to let people know if they want to talk. Can you imagine if they don't get notice? We have a problem if they don't get a notice.
Well, yeah, and if they don't get a notice, do they get to come back and reopen the case? I mean, how often does that happen?
We don't have to spend a lot of time on this. I think we get the sense of the board. There'll be a whole slew of changes that are going to be proposed. So to make it, again, this is just something where it's under consideration. That's all. Nothing's going to happen overnight.
Anybody else have any new business?
We got to approve the minutes of December 2nd and January 2nd, if I'm not mistaken.
Yes, we do.
I make the motion to approve the minutes.
All those in favor? Second? Everybody, we're all on board for that? Wendy, you say yes?
Yes.
Okay. Unanimous. Anything else?
No.
I guess we'll move to adjourn.
I'll make a motion to adjourn.
Second,
I'll
all
second.
those in favor?
Who seconded it?
Dave,
George,
Dave
or I
Collins,
did.
second. Dave
We-
Collins,
we all-
second.
Seconded
we
it.
all- it was a trample to the finish.
Hey, have a good night, everybody.